First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, great state of Florida, and this honorable court.
Thank you. You may be seated. Good afternoon and welcome to the First District Court of Appeal. We have two cases on our docket this afternoon. We'll take them in order. The first case number 21-3417, Michelle Wilson versus Florida Commission on Human Rights. If Appellant's counsel is ready.
May it please the court, I'm Rick Johnson, Tallahassee, Florida, for the appellant, Michelle Wilson. Michelle Wilson worked at FCHR for 17 years.
Briefly, counsel, would you like to reserve any time for rebuttal?
Yes, sir, 5 minutes, please.
Very good.
Michelle Wilson worked at FCHR for 17 years, 9 of them as executive director, which is the chief executive officer of that organization. She was ordered to violate a statutory mandate to investigate discrimination cases. She was ordered to dismiss them without investigation. She objected to that, and she was fired as a result of her refusal to violate that statute. She filed a whistleblower charge with FCHR and with the Inspector General's office because the relevant statute said that you could file it with either, and so we filed it with both.
So is the issue that you just mentioned in the statute, is that kind of the same issue that we're on here today, how cases get processed, whether they're investigated or whether they get dismissed?
That's one of the issues.
Well, didn't we resolve that, though, in Stanton and some of the other cases where we said if there's not a prima facie case stated in a complaint, the commission is empowered to dismiss the complaint?
Well, yeah, but, in the course of this briefing, in between the initial brief and the answer brief, you put out another case called Al-Badi versus Walt Disney World that said the prima facie case is not necessary at FCHR, and you had never considered prior to that any of the constitutional issues that I've raised because the previous appellants never presented those constitutional issues. And so I think you might have decided some of those earlier cases like Tillery, Stanton, and Caldwell differently if those issues had been argued.
Well, can I go back to the whistleblower statute that Judge Osterhaus was asking you about? Assuming that, being asked to dismiss the case or cases that was protected activity, who was that disclosed to prior to her termination such that triggered the protection of the act?
It was disclosed to the commission, which is the governing body. That was the body that did the firing. They're the ultimate authority there. So one of the things...
Was that a written disclosure, or in what form did the disclosure?
Your Honor, I have a hearing aid appointment scheduled.
Was that
I haven't got the hearing aids yet.
Was that a written disclosure, or what form did the disclosure to the commission take?
She did disclosures orally at meetings, and she also wrote a few memoranda on various issues. Now,
so are the memoranda on the order of kind of the briefing that we have here today, that there's this question of law that were addressed in that trilogy of cases in 2013 that was still being wrestled with? You said that she disclosed to the commission through legal memoranda and other ways.
Orally at meetings, yes.
And was her disclosure along the lines of the briefing that we have here in this case, that there are different sides of this question that were addressed by those three cases in 2013?
It wasn't about those issues that were discussed by those cases in 2013, it was that there is a law against what you're ordering me to do, and I cannot violate the law that you're ordering me to violate. That was the nature of the disclosure. It was that we're required to investigate every case by statute, and you're telling me get rid of these cases without investigating them, and I can't do that. So that was the primary nature of the disclosure. And we raised the issue that you have a conflict of interest with this commission. You're the ones that fired her. You're being asked to judge your own conduct.
Can I ask you about that? As I understand it, that was raised only in your initial email to the commission when the complaint was filed. Is that correct?
Yes, Your Honor.
There was not, and you said you might have a conflict, but you didn't at that point demand that they disqualify, right?
Well, yeah, I mean, I didn't beat him over the head with it, but I think I made it pretty clear that you have somebody else that you can refer this to, and you have a conflict of interest, and that's why I'm dual filing this complaint with both agencies. And I assumed that they could figure it out because they had just finished the case of Jacqueline Steele, and they referred her case over to the Attorney General to investigate because she was an employee of the agency, and she was fired by staff. She wasn't fired by the commission, fired by the board. So that's the superior of everybody over there, and anybody who found anything against them would be fearful. They would be jeopardizing their own employment.
Am I correct that besides your initial email where you mentioned the issue, it wasn't raised in any of the further communications that you had with the commission or the commission's attorneys?
I didn't raise it again, no, didn't raise it again. I think that even under the old precedents, even under the trilogy that Judge Osterhaus mentioned of Tillery, Stanton, and Caldwell, that our case passes muster because it fulfills all the requirements. It says all the things that are required to be said. It includes everything that's meant to be included. Secondly, there is a statute, and the statute requires that FCHR make a determination. It doesn't say that they can dismiss it or annihilate the charge without processing it or without making the determination. And then we have the prima facie case issue, which this court has subsequently put out the Walt Disney World opinion saying the prima facie case is not necessary at the FCHR level. Then we have FCHR unconstitutionally exercising both legislative and judicial power. Legislative power to amend a statute and the judicial power to determine a case of unliquidated damages, which is something that only a court can do. And then we have the due process, where the process is arbitrary, is capricious, it has no standards, it's whatever they feel like dismissing or saying does not meet their jurisdiction or is not something they have the authority to answer. And then we have the trial by jury, which this court decided in the FAMU case. And then we have the access to courts under Aldana versus Holem, which says you cannot put all those obstacles in front of somebody, procedural obstacles, to keep them from going to court. And that if you do keep them from going to court, you have to offer them an alternative remedy, the way the workers' comp statute did when it took away the tort right, and the way that the employment discrimination statute that FCHR administers also does. When they take away their right to court, they give them the right to go to DOA for a full dress bench trial, and eventually to get to court if they run that gauntlet.
Well, could it be possible though to analogize this to like a medical malpractice complaint where there's a condition precedent that has to be fulfilled before you're able to go to court, and the Supreme Court has said that's okay. You're not depriving somebody of the access to court by having to go through the pre-suit screening requirements.
Yes, sir. That's exactly right. That's Aldana versus Holum. The catch is that there you eventually get to court. Here you don't. Your case is annihilated at the pre-suit level, and it can't go anywhere except here. And, you know, here, with all due respect, is not like going to a court where there's evidence and witnesses and full due process rights. And so, yeah, that due process is a fairly important thing. I see that I'm into my rebuttal time. I'll answer questions and I'll sit down.
Thank you, counsel.
Thank you. May it please the court, I'm Jamie Ito on behalf of the Florida Commission on Human Relations, which is a mouthful, so I'm going to just refer to the commission. The commission's denial or dismissal of the appellant's charge should be affirmed because the commission exercised its inherent authority to dismiss charges that failed to meet the pleading requirement to trigger the authority to investigate by the commission. That the appellant's charge and amended charges both failed to plead whistleblower activity. I don't think that there's a dispute that the law says there is inherent authority to dismiss charges, and that dates back to the Robinson case when this court first said that untimely charges can be dismissed.
Is this case like one of those three trilogy cases, or on what basis was the dismissal here made?
Yeah, it's similar to Tillery, Stanton, and Caldwell in that one of the elements of a whistleblower retaliation case was not met. In Tillery, it was, whether or not there was a protected disclosure in that the charge did not indicate who the disclosure had been made to. In Stanton, the charge did not allege the causation element. That's why the commission dismissed it. And then this court went on to say, furthermore, the charge did not indicate that the person to whom the disclosure was made had any authority, any supervisory authority, and could receive that disclosure.
So which of the defects from these cases apply here?
So the defect in this case is that no protected activity was stated, no protected activity per the Whistleblower Act. So the Whistleblower Act is pretty specific about what a disclosure has to be to meet the standard to be protected disclosure. It has to disclose a violation of law, rule, policy, or that presents a substantial danger to the public health or well-being, or it has to set forth gross misfeasance, malfeasance, fraud, that sort of thing.
What about Mr. Johnson's assertion that Ms. Wilson had submitted memoranda to the commission raising her concerns?
Well, that is actually the first time I have heard about this memorandum today. The memorandum is not alleged in the charge, and it's not alleged in the amended charge. So the commission didn't have that in front of it when it was deciding whether or not the charge was sufficient. The memorandum isn't part of the records. It's not described anywhere, so I don't really know what to do with that, except that I don't think that argument here today that there was a memorandum could be a basis for reversal. Most of the
Does
charge...
that kind of scenario sound in a protected disclosure to the extent that a counsel's that a legal position within an agency, that people on different sides of a legal position in an agency, I would guess that counsel's office and advising, secretaries' offices are often on different sides of things, or they work towards a resolution of things, and maybe they're in different places. I guess I'm struggling with that concept that to the extent that the commission here had a view that was, it sounds like similar to the first DCA's, and the director thought that the statute should be interpreted differently, is that the kind of thing that would even rise to the level of a protected disclosure?
No, our position is that these debates and discussions at the commission meetings about, what do we as a commission, what are we charged with, what do we have to investigate, what can we fairly dismiss at the outset, they're just debates and discussions. And to the extent that Ms. Wilson disagreed with the commission, she didn't report, hey, you guys have been violating the law by dismissing these charges. That's not in there. It's just her saying, I disagree. I think that, if you want to continue to dismiss charges at the outset, that would require a legislative fix. She didn't report that any statute or law had been violated.
Now, the statute does have a pretty low bar, right? And in reading it, suspected misfeasance sounds to me like it covers a whole lot.
Right, but suspected misfeasance, when we have the court here telling us, you can dismiss charges that aren't timely. You can dismiss charges when they only conclusory allegations of causation. You can dismiss charges when you don't indicate to whom a disclosure is made. And then we also have this court construing, what is and is not a whistleblower charge when reviewing summary judgment orders. And so we've got those cases that further narrow down what is and is not a whistleblower charge or a whistleblower disclosure, like the Nizal case, where several incident reports reporting, mistreatment by a supervisor, those were held to be not protected disclosure. The Pickford case, as an employee's, a teacher's letter to his principal saying, hey, I'm not being paid the right salary, you need to pay me as a full-time salary, I'm only getting substitute salary, that was held to not be a whistleblower disclosure. And then the Washington versus the Department of Revenue case, where this employee's written rebuttal saying, hey, I was unfairly disciplined, that was not a whistleblower disclosure. So these things that, you might say, well, I think that's misfeasance. I think unfairly disciplining somebody is misfeasance. Well, the court tells us that it's not. And then she goes on, in addition to having these disagreements about, what charges can and cannot be dismissed, she raises the issue of performance evaluations. What are the performance standards? When are we going to get evaluated? Again, that disclosure, it's not a disclosure, it's a question, and I would say that falls under the cases that tell us, these sorts of communications are not protected disclosures.
What is your response to appellant's reliance on Appellee v. Disney?
That's what I was about to get into. So Appellee is a discrimination case, and so it's not a whistleblower case, and that's important because with a Florida Civil Rights Act or a Title VII discrimination case, you can survive summary judgment without meeting the traditional burden shifting framework that requires a prima facie case, and then the burden shifts back and forth, because you can also show a convincing mosaic of circumstantial evidence to get around that burden shifting framework. And you can also have direct evidence of discrimination. And so the fact in a body that the fact that there was no prima facie case, well, that doesn't matter because you have these two other ways to make your case. But with a whistleblower case, a whistleblower disclosure, a protected disclosure is always going to be required. So I don't think a body applies at all.
Can I ask you about the claim that the commission should have disqualified itself early on? Why were they entitled to investigate this complaint concerning their executive director? I mean, there's nobody higher in the commission. I would assume that it seems like that's somewhat problematic. So how do you respond to that?
Well, first of all, we never even get to an investigation. So that would presume that the charge actually stated a claim. Say they did find, hypothetically, say they did find the charge was sufficient and then went on to investigate it themselves rather than referring it out to another entity. Well, that's what the statute says. 112.31895 says that whistleblower charges can be filed with the CIG or with the FCHR, but then it goes on to provide in the next section that the Florida Commission on Human Relations shall conduct the fact-finding. There's nothing in that statute about the CIG conducting fact-finding. What the CIG does is they investigate the underlying disclosure, the underlying fraud or the underlying, waste of public funds, and then they make recommendations or criminal referrals if necessary to FDLE or whatever. But the statute does not provide that they can't. And if they can, well, then Ms. Wilson dual filed. She filed with the FCHR and she filed with the CIG. If they have that authority, that power, then why aren't they here? Maybe they're investigating. It's not in the record. But if their power to investigate is there, then they've got it. And so whatever FCHR did or didn't do shouldn't matter. I don't think they have the authority to investigate. So
Does the commission sometimes outsource it to?
yes, there are, and the rules provide for, I think it's called referral agreements, and that has happened. And it could be that if this charge had pled a case, then maybe it would have been outsourced. But you have to meet that first hurdle. You have to say, on X date, I submitted this memorandum and I identified this violation of law was happening. And that just didn't happen here. It's the charge and the amended charge are a little bit rambling. It talks a lot about, the drama between commissioners, the politics between commissioners, and, accuses some of having nefarious motives. But it doesn't identify anything that has happened, any commissioner that has violated the law or, engaged in any sort of misfeasance or malfeasance.
Did the amended complaint satisfy, I know you contend, and the commission found it doesn't state a prima facie case. Did it satisfy the pleading requirements otherwise under the administrative code, the 60Y 5.001?
Well, it clearly alleged that an adverse employment action. It alleged that she had been dismissed. So you've got to allege the protected activity, an adverse action, and then causation. So yes to 2, no to 1. And then as far as causation, I think that's a much more flexible pleading standard, because really for causation, all you have to show is that these two things are not unrelated.
Well, what I was trying to get at, and I guess I should have been more specific, it says the complaint must be in writing and signed by the complainant. The complaint shall be verified. Is that only the initial complaint, or must an amended complaint comply with those requirements?
Well, I would say that an amended complaint also, ideally, the amended complaint would have been, again, on the form with the signature and date and notarized. Instead, it came by email. The agency didn't reject it for failing to be verified. But technically, no, I don't believe it met that requirement. So, I know I only have a couple more minutes, but all these constitutional issues, of course, you really only get to, if you have to first get past the hurdle of stating a claim. No claim was stated here, so, there is no right to a jury trial when you don't state a claim. There's no right to access the court or due process. This is a public employee in Florida where we know we have no, constitutional due process right to continued employment, and it's an at-will state. So I don't think that that due process right is implicated. The separation of powers, the agency has been charged with this, and the agency has been told by the courts that it has power to dismiss these claims. So it's not usurping the judiciary's function And if you don't have any further questions, we would just ask that you affirm the order dismissing the charge.
Thank you, counsel.
Your Honor, what the investigation is supposed to do is uncover all the relevant documents and all the relevant testimony. And so I feel like we're in a catch-22 here, where they're saying, well, you didn't give us all the memoranda. Well, the memoranda and all the witness testimony are what the investigation is supposed to uncover. And, I think we're losing sight of the fact that this statute is written for a sixth grade educated groundskeeper who works for the state, who can write something on pencil and turn it in and have some agency employee flesh it out for them and do enough investigation to find out whether they have a charge or not. That's what the purpose of the statute is.
You think we'd have to go en banc? Because that sounds like a pretty sweeping rule that would knock out those 3 cases from 2013.
Well, I don't want to say that those 3 cases were wrong, but certainly the latter 2 of them were. But you can't do anything about that, so I won't ask you. You're not the en banc court. You can't reverse those. So what I'm arguing that within the framework of those cases, first we've presented an adequate case, and
Is there any bare minimum in such a complaint under the rule that you would have us adopt?
not that I've ever seen. Most of the cases are the federal EEOC cases that discuss that. But this is a statute where the initial charge is meant to be pro se by persons that may have very limited literacy skills.
So if someone files a case having to do with basically a nuisance suit, somebody blowing a whistle in the middle of the night, and it's obviously doesn't belong here, nevertheless, it's a complaint filed before the commission and they need to go through and not dismiss it.
No, yeah, there's very clearly subject matter jurisdiction. If you go to FCHR and ask them for a divorce, they can say, no, we don't have any jurisdiction over that. But if they come in and they say, my employer fired me because I didn't want to break the law, and that's all they can say, that's the limit of their literacy skills, you ask some questions, and you go into it, and you find out enough to know whether there's any merit to the case or not, and sometimes the commission takes over the advocate role in those cases, and I've seen that done many a time, and there's some of those cases that have been before your court, one of the things that Ms. Ito, who is very good at this, was saying about a body that's unique to public accommodations cases or employment cases. No, because what a body did was it cited the federal civil rights cases as its basis, and so it certainly deals with cases where there's prima facie case and where there's not prima facie case. So it just simply says that you can't impose all of these summary judgment type hurdles at the early stage of a case where there hasn't even been discovery yet, where there hasn't, and in this case, where there hasn't even been a complaint in court filed. This is way too early a stage to be killing off a complaint so that it can't go to DOA, it can't go to PERC, it can't go to circuit court, it can't go anywhere where you can present your documents, where you can present your witnesses, where you can make your case, where you can get discovery from the opposing side. You can't have due process if you don't have any of those things. There's a statute that the legislature created, and they said in there that it's to be liberally construed to do everything to grant access to the remedy. where there's any any distinction between getting access to the remedy and not getting it, you grant it. Thank you very much. My time's up.
Thank you. All right, the second case on our docket this afternoon is ABM Industries versus Maritza Valencia, case number 22-725. Appellant's counsel, when you're ready.
May it please the court. Thank you, Your Honors. Good afternoon. My name is Erica Dalton, and I'm here today on behalf of the appellants, ABM Industries and ESIS, in the second workers' compensation appeal in this case. We would like to reserve 5 minutes for rebuttal.
Good.
The start of this appeal, Your Honors, begins with a remand from this court instructing the JCC to, quote, address the EMA request in light of the record conflict between the opinions of Drs. Rosabal and Lazarin. As instructed, the JCC issued questions to the appointed EMA, Dr. Rosenzweig in this case, based on the record conflict, but then refused to afford the presumption of correctness to the EMA's answers that were directly responsive to the JCC's questions.
Well, can I ask you about that? The record conflict on the first appeal, was that not just the need for surgery? There may have been further conflict potentially developed, but at the time, and I know the remand wasn't specific, but the language that you accurately quoted does talk about the record conflict between the opinions. Wasn't that the only conflict at the time, the need for surgery?
No, Your Honor. The record reflected the deposition transcripts of both Drs. Rosabal and Drs. Lazarin, the two authorized doctors in this case, which reflected numerous medical disputes as to diagnoses, major contributing cause, proper treatment, and the work restrictions. The record conflict includes the deposition testimonies of the authorized doctors as well as their medical records.
I thought that ABM's or the EC's notice in the first case of the potential conflict dealt only with the need for surgery. Is that not correct?
I should note, Your Honor, that the notice of contingent conflict that the JCC is relying on in this case was one of 5 requests that were made. This court had acknowledged the 5 requests that were made. There was a motion to bifurcate, requesting that an EMA be appointed based on all existing medical conflicts, as reflected in the deposition testimonies of Drs. Rosabal and Dr. Lazarin. There was a second motion, the notice of contingent conflict, which did highlight the medical dispute as to surgery. There was the renewed request in her trial memorandum. There was also a renewed request at trial itself. And, Your Honor, there was a post-trial request for an EMA based on the record conflict, because at that point, Dr. Lazarin was deemed authorized, and all of the medical disputes became apparent. As a result of the JCC's refusal to afford the presumption of correctness to all of the questions that were answered by the EMA, the nearly conclusive effect of the EMA's opinions was stripped, even though those opinions were rigidly within the scope that had already been determined by the JCC. Procedurally, after the opinion and mandate of this court, an evidentiary hearing was held on October 26, 2021. It was specifically for the purpose of determining the scope of the EMA. The next day, the JCC issued an outgoing correspondence to that EMA soliciting the opinions of that doctor on the following 6 medical disputes.
Now, is your argument that once a JCC lays out, say, six areas of investigation and of an EMA report, that the JCC can't later decide that some of those weren't actually, should not have been referred to the EMA, that there's kind of a preclusion that goes on?
Yes, Your Honor, that is exactly our point here. The statute for 4013 subsection 9 requires the parties to make a written request for an EMA. Based on taking that in conjunction with the Beekman case, which finds that certainly an EMA is charged with answering the questions posed by the JCC, I think it becomes clear that determining the scope of an EMA is a task of factual finding. That task was discharged when an evidentiary hearing was held in this specific case, and the following day, the judge had issued her scope, the amended correspondence to the EMA, indicating that these are the factual findings as to the medical disputes.
If you can't take away from the scope, can you add to the scope, or it only works one way?
I'm not sure, Your Honor. In this case, truly there is only the attempt to be taken away. I think once the scope is determined, the scope is determined. So my answer would be no.
So if the scope was determined to be one issue, the EMA couldn't, or the JCC couldn't later say, wait, I'm going to add 5 more?
I think at the point that the correspondence goes out to the EMA is the determining factor here. In Beekman, if I may, I think it's paramount to note that in that case, a notice of conflict was filed by the claimant as to the discrepancy whether an arthroscopy was needed, a shoulder surgery. The JCC independently had found that innate to that conflict, there also exist disagreements as to diagnoses, causal relationship, and recommended treatment, and sua sponte expanded the scope of the EMA prior to issuing the questions to that EMA. In that case, when the EMA answered questions on apportionment, not part of the questions that were issued to the EMA, he was found to have exceeded the scope. So based on the existing precedent of this court, an EMA exceeds the scope when he answers questions that were not posed to him. That did not happen in this case.
Can I go back to what Judge Osterhaus was asking you, though? In making an order after a evidentiary hearing, that's not a final order there, right, that said these are the 6 questions to the EMA. Nobody could have appealed that, right? So until there's a final, appealable final order, isn't any fact finder entitled to change his or her mind till a final ruling is made in a case?
I have 2 points on this, Your Honor. We are here today under with the position that those are factual findings. It is required of the parties to make it's not even required of the parties to make a request for an EMA. It's required of the JCC to appoint an EMA when medical disputes become evident. When the factual determination, in this case an evidentiary hearing, was held, and the next day there was questions that were issued to the EMA making factual findings as to the medical disputes, that is appealable. And to date, there has been not only no appeal, there's been no cross appeal, there's been no motion for rehearing on that, there's been no filing of objections by the claimant. The appellate process was not utilized by the claimant in this scenario. My second point on this, Your Honor, if I may, is that in her final compensation order, which is most definitely final, she confirms that these medical disputes exist. She finds, I believe, the JCC finds on pages 21 and 22 that the medical disputes were in existence. She confirms that. The reasoning why she refuses to afford the presumption of correctness is based on the fact not that the medical disputes do not exist, but it's based on the fact that the employer carrier did not raise in one of its 5 requests for an EMA all medical disputes. On this point, Your Honors, I believe that the JCC has erred in 3 different ways. First, the JCC has misinterpreted how the scope of an EMA is determined and how the presumption of correctness applies. As I stated, per Section 440.13, subsection 9, it is the job of the parties to provide written request of an EMA, nothing more than that. This was done, and this court recognized that. They called our request, I'm sorry, Your Honors, you had called our request well-preserved numerous times. It is then the job of the JCC to determine the extent of the disputes based upon the record evidence. This was also done. At the October 26th hearing, the deposition transcripts of both Drs. Roosevelt and Lazarin, both of which were previously entered into evidence at the first and second final hearing on remand, were reviewed and discussed, and the next day, the scope was outlined. It was further confirmed in the JCC's order that the medical disputes did exist, a factual finding that has not been appealed today.
Did Dr. Rosenbaum and Lazarin agree that the claimant wasn't at MMI?
Judge, that is the only medical dispute in her order that she finds did not exist, and in fact, she states that question should not have been posed to the EMA. I believe it's on page 28 of the record in her order. I have 2 points again on this question, Your Honor. The first one is it was posed. The scope was laid out very clearly.
But what about the disagreement? Was there a disagreement between the 2 doctors on MMI?
There was no, her finding, Your Honor, which isn't on appeal today, is that there was no medical dispute.
So if there's no disagreement, then it looks like 440.13.9c doesn't apply, right?
Judge, I would respectfully disagree. I think that the scope is laid out when the JCC issues the questions. She made factual findings. There was an evidentiary hearing, and she agreed that this medical dispute existed. If those were incorrect factual findings, they should be appealed. The question as to MMI was posed, and that was a factual finding by the judge that was made, that she is now retroactively trying to undo after the scope has already been made. On that point as well, Your Honor, there is no other findings in her order that other medical disputes do not exist. They did exist. She confirms that they actually did exist. The reason the presumption of correctness, the nearly conclusive effect of the EMA is not being applied is not because the medical disputes do not exist. This is key. It's because the EC did not raise them in one of their requests. Our point on this today, Your Honor, is this is, in addition to the reason we've already stated, excuse me, this is also a violation of due process. There is nowhere in the record where it states, where you'll find that the claimant is arguing that because the EC did not raise this, all disputes in one of its requests for an EMA, that is the reason it should not be applied. They are arguing that the medical disputes did not exist. There's 2 different arguments going on here. The claimant saying that the medical disputes did not exist in their trial memorandum at trial and still on appeal today. The judge is finding that they did exist. It's a factual finding in her order that confirms the scope that went out to the EMA.
Counsel, you're more than 2 minutes into your rebuttal time. I just wanted to make you aware.
Thank you, Your Honor. I think the point here is that the judge reaches her conclusion by raising a defense that was not even raised by the claimant, and this is a violation of due process. The employer carrier had no opportunity to defend against it or offer evidence to the contrary of her findings. This court found in the School District of Hillsborough County v. Dixon case that the JCC violated an EC's right to due process by sua sponte, raising the application of 440.22 by denying the EC the opportunity to present evidence regarding the section's applicability. That's exactly what happened here. The claimant has not raised whatsoever that the EMA should not be afforded the presumption of correctness because the EC did not raise the request in its first request for an EMA. Thank you, Your Honors.
Good afternoon, and may it please the court. I am Mark Zients of Pinecrest, Florida, and I am here representing the appellee, who was the subject of an order appealed by the employee carrier and not cross-appealed by the claimant. The claimant lost in that order the right to have surgery and the right to have therapy. So the only thing that could possibly be on appeal is the period of temporary total disability that the judge awarded. In the appellant's brief, she raises 3 points, and the 3 points are all interrelated with the appointment of the EMA. The first point is that the JCC is bound by its previous determination of the scope of the disputes. The scope of the dispute that this court heard and ruled upon and felt that there was a need for an EMA was the right to have surgery. It wasn't a major contributing cause. It wasn't any other legal issue, and the judge appointed an EMA for that purpose. Then came the defendants, who had not raised properly any of these other issues. On the eve of trial, they submitted a trial memorandum for the first time, raising major contributing cause and other defenses for which the appellee was certainly not prepared to defend and was not properly before the judge. She had no right to rule on those issues. They had never been brought up before. In addition, the bounds of a hearing in workers' comp is the pretrial. And if you look at the pretrial, there's no issue of major contributing cause. There's no other defense raised other than Dr. Lazarin is not an authorized doctor. So once this court heard the first appeal, it ruled that Dr. Lazarin was an authorized doctor. Dr. Lazarin is the only one of all of the 3 doctors involved in this case who opined on the ability to work during the specific period of time that the claimant was awarded. Dr. Rosenzweig, I have difficulty with that name, did not opine on the end of the period of temporary total until he saw the claimant. He also testified that he did not know whether she was able to work or not able to work during the period of time in question. So there's no conflict on the temporary total benefits that were awarded. So even if the judge gave the presumption of correctness to Dr. Rosenzweig on that issue, the claimant still would have prevailed because he didn't have an opinion. And this court has said that if an EMA doesn't give an opinion, then there's nothing to decide.
What is your thought on this black letter rule that once a JCC sets the bounds of the EMA's investigation and report back, that's locked and that can't be revisited?
I would not say that the JCC has no discretion to expand the scope of the EMA, but I think there has to be a hearing held to allow the parties to rebut any possible conflict. If you notice, when the defense asked for 5 questions, the claimant had already presented her case case was over. The appellate court had ruled that an EMA was necessary for surgery. And under those circumstances, I think the JCC is limited. If you're in the midst of trial or you're pre-trial and a dispute arises and the JCC decides to employ an EMA, she can pick whatever subjects she believes are in conflict. And if she's wrong, she would be overturned on appeal. But if you look at the questions that were asked of Dr. Rosenzweig once the case went to that stage, please provide an exact diagnosis for claimant's condition relating to her left knee. There's no evidence of record that there's a conflict there. Nobody raised it. Is the industrial injury the major contributing cause of claimant's knee condition? The employer carrier had admitted that. They had found, they put on the pretrial, the knee injury is compensable. That does away with major contributing cause, because if it's not the major contributing cause, it's not compensable. So that's question number two. Number three, what, if any, treatment would you prescribe for the claimant's knee? Well, Dr. Rosenzweig basically said none. Dr. Rosenbaum wanted more testing, and Dr. Lazarin wanted surgery. So that question is covered by the surgery issue. What treatment is appropriate? The EMA said no treatment, no surgery. The judge went along with it. The claimant did not complain and cross appeal. Fourth question, is surgery recommended for the claimant's left knee? And if so, what procedure? Well, we know Dr. Lazarin outlined in his testimony what he would try to do to correct the torn meniscus and find out whether or not there were any other conditions during arthroscopic invasion that needed to be corrected, such as shaving down the arthritis behind the kneecap. But Dr. Rosenbaum did not tell us any procedure. He just basically said, I need more testing. There's something else going on here, and I want to investigate it. There's no conflict. Does claimant have any work restrictions, and if so, provide details? Dr. Rosenzweig clearly said, I wasn't there at the beginning. I didn't see her until a particular date. I can't tell you what her condition was then. So there is no conflict between his opinion and the opinion of Dr. Lazarin, who said no work as of the particular date that the judge began an award of temporary total. The last question is claimant at MMI. And that's the most interesting one of all, because both Dr. Lazarin and Dr. Rosenbaum said that she was not at MMI. There's no conflict. Why would you ask that question? This is what Judge Alan Schwartz used to call the gotcha defense, that we're going to wait till the very last minute on the eve of trial or even afterwards, after an appeal, to come up with new defenses that they hadn't raised before in any proceeding. And that deprives the injured worker of due process. How could he possibly overcome the presumption if he didn't know it was going to be asked of the EMA ahead of time? And he did not know it was going to be asked because it wasn't raised anyplace. It wasn't raised in the memos of law.
But once the JCC asks about an evaluation of MMI to the EMA, does that evaluation get a presumption of correctness? Hard and fast,
no,
without being able to take it back?
I think it's merely an opinion, one of three that the judge could choose. She followed your decision in the
Beekman?
not good when you lose page 3. He followed your decision in the Beekman case. In Beekman, they talked about already identified disagreements. There weren't any except surgery. So MMI had not been addressed as a disagreement. Causation had not been discussed as a disagreement because it was stipulated to. Major contributing cause was not a disagreement because it was stipulated to. The entire left knee was compensable. So all the additional questions did was bring up issues that had already been resolved or stipulated to. And by doing that, deprive the claimant of due process. How can you rebut that by clear and convincing evidence if the trial's over? It's not a procedure which this court should put the stamp of approval on, because it will lead to defense attorneys, after an order is entered, coming in and saying, wait a minute, we think there's a conflict between A and B, and we want you to appoint an EMA. And a judge can do that even after the hearings are over, even during the hearings. But there has to be a specifically identified disagreement in the medical opinions. Beekman says you can listen to the opinions of the EMA on questions that do not pose disagreements, but you can only consider those opinions as opinions of an IME or an authorized doctor, not as an EMA, not with a presumption. And by doing that, the judge clearly indicated that she was going to rule on the issue before her, and surgery she ruled out, physical therapy she ruled out, based on the EMA and the questions that were presented that had medical disputes identified. The rest of it was just a way of expanding the appeal way beyond what this court envisioned when it asked the JCC to appoint an EMA. So we would ask you to affirm.
Thank you, counsel.
I have quite a few points I'm going to try to move through very swiftly, Your Honors. My first point is that the contention that medical disputes did not exist as between Drs. Roosevelt and Dr. Lazarin, with the exception of the finding of MMI was not in existence, is not an issue that's preserved for appeal. There was factual findings made that these disputes existed, and that was not cross-appealed. My second point is the appellee has stated here today that there must be a hearing held. That happened. There was an evidentiary hearing with regard to the medical disputes. This hearing and the next day correspondence does away with any error that the EC may have possibly committed by not putting all medical disputes in its notice of contingent conflict. Third, by the JCC's very logic, this highlights yet another due process violation in addition to the fact that the claimant and the JCC are arguing different things. And here it is on page 852 of the record, in her nunc-pro-tunc order from 2020, quote, "There is no provision in the statute for an appointment of an EMA for a contingent dispute. The dispute must be present when the request is made. In this case, there was no dispute present because through the end of the final hearing, Dr. Lazarin was not authorized. Only when the amended final merits order was entered did Dr. Lazarin become authorized. As a result, there was no dispute before or during the final hearing that could justify appointment of the EMA." By the judge's own logic, we have to look at what happened after. And there was a renewed motion as well as an appeal, which instructed the JCC to look at the record conflict, and she did so through an evidentiary hearing. My fourth point is on the existence of TTD. The judge finds on page 25 that the EMA found there was no restrictions necessary. This is what comports with his deposition testimony on pages 194 and 195, which says she requires no restrictions. That's my time. Thank you, Your Honors.
Thank you. That concludes our cases for today. The court will be adjourned.
All rise.
Oh, pretty nice to meet you. Good job.
We're done.